and hit record on this computer. We are now recording. And hello, everybody. I want to welcome you, and I want to say thank you for joining me tonight. So hello, everybody. My name is TJ Scott, and I am an estate planning attorney with the law office of Timothy J. Scott. And being an estate planning attorney means that I help people to avoid court and conflict in their family when something happens to them, meaning either incapacity or death, avoiding that court and conflict that so often can tear down families and really make life difficult when really the family should just be grieving the loss of somebody important in their family, namely you. So I am so happy to have you here with me today. And we are going to be talking today about something that I know is a really difficult topic. And I know it's difficult, but I also believe that knowledge is power. And I want to give you that knowledge tonight. I really want to empower you around this topic so that you can have peace of mind when you think about this, that you don't have to worry about it anymore. You either have it sorted or at least you know what's going to happen in your family. And so it's not something that you have to spend time worrying about, spend time being concerned about. And I want to empower you today. And I also have a lot of valuable information to share with you, as well as some valuable offers that I'm going to be sharing at the end of the presentation. So I hope that you'll stay with me all the way through to the end. All right, well, let's dive in here. And let me start with this. The best way to learn tonight, the best way to really absorb this information and to most fully empower yourself is to be present here with me. Turn off the distractions. If you have another tab open or another window open, I really encourage you to go ahead and shut that right now. And give yourself the time that you've set aside to be here and the time that you've dedicated to learning this information. I always say your future self is really going to be glad that you have set this side of time and that you've committed this time to being here with me and learning this information. And if you stick around until the end, and I hope that you will, again, I have a ton of information to give you, but right at the end, I'm going to be making some offers to you that is going to make it even easier to get an estate plan in place for your family. One of those offers is a free virtual one-on-one meeting with me, where we're going to talk about, or where we have the opportunity to talk about all the things that you have and the people that you love and how you can protect them by getting an estate plan in place that's going to cover them and make sure that they're well taken care of. Plus, I have a bonus gift that's going to make it even easier to get a personalized and tailored estate plan in place. Again, just stick with me until the end and you'll see what those offers are. But the first thing that I want to do here, I want to take a poll of our audience. And the first question that I have for you is, do you have an estate plan in place? And so you should see a poll pop up and you should be able to answer it yes or no. The elements that I have on the screen right now, a trust, a will, guardianship nomination, healthcare directive, power of attorney, beneficiary designation, these are all really parts of an estate plan. None of those items in and of themselves are an estate plan. And in fact, an estate plan, I think, includes some other things that aren't even on the screen here. But a lot of times I hear from people, what is the difference between a will and an estate plan? Or, I have a will in place, so I don't really need to worry about that estate planning thing. And tonight, I really want to address that. I want to speak to that question a little bit because oftentimes people don't realize that a will isn't going to help you avoid probate. It may not be serving your family in the way that you want to serve your family with your estate plan. And so I see in the responses, it looks like I'm seeing no estate plan in place, principally. And so I really thank you for sharing that. And if that's the case, I also just want to let you know you're not alone. You're not the only person who doesn't have an estate plan in place. There are lots of people out there who don't. In fact, one of the most recent statistics that I've seen is 69% of people in America currently do not have an estate plan in place. But if that's the case, I just want to ask you, does something on this new poll resonate with you? Maybe you've been too busy, and I completely get it. As a father of 3 young kids, somebody who has started their own business and is a lawyer out there doing a lot of work for a lot of different people, I totally get it. Life is really busy. But if that's the case, again, I just want to commend you for being here tonight, for taking the time, setting it aside, and being with me to learn about this topic and see what you can do for the people that you love in order to make sure they're taken care of. And maybe you feel like you're too young, but the reality is anyone over the age of 18 should really have some fundamental, some foundational estate planning in place. I was recently helping, and it's not even as recent as it once was, but recently I was helping a young family where a young father had passed away. And unfortunately, he left something of a mess for his wife and minor daughters. But that didn't have to be the case. There's never, once you're over the age of 18, you're never too young to have some foundational estate planning documents in place. And they are just going to help relieve a lot of headaches for your family if the unlikely event of something happening to you does occur. And maybe you feel like estate planning is too expensive. And before word processing was as widespread as it is now, maybe that was true. But today, estate planning really is accessible for everybody. And I have some bonuses again at the end that I will that you're going to see are going to make it even more affordable and easy to get an estate plan in place. Or maybe you're worried about jinxing yourself. And honestly, maybe you're not willing to admit that you're worried about jinxing yourself, but maybe that is in the back of your mind. And I understand that. I've heard that from a lot of clients. And I want to put your mind at ease. I've done dozens of estate plans, and luckily, I've never seen a correlation between somebody getting their estate plan done and having something happen to them. In fact, I always say my clients tend to live more intentionally, more purposefully, and get more enjoyment from their lives knowing what's going to happen when they're gone. So thanks again for answering that poll. If you did, I really appreciate it. I really enjoy seeing your answers. Next question that I have for you is, if you do have a plan in place, what do you want to learn tonight? And even if you don't have a plan in place, is there something on this poll? Is there something on this list that resonates with you? Maybe you want to know, maybe you've been thinking about doing an online do-it-yourself will, or maybe you already have one done and you want to know if that's okay, if that's going to take care of your family the way that you want your family taken care of after you're gone. Or maybe you did an estate plan, but it's been a long time since you had that estate plan done. And now you're wondering if it's outdated, if it needs to be updated for your current situation or for the current law, and you want to find that out. Or maybe you did an estate plan in the past, but the attorney who helped you with that estate plan didn't exactly bring you along with during the process. And I hear that from a lot of people, that they didn't really understand what the attorney was doing, and they know that they have this estate plan, but they're not really sure what it means. And maybe you just want a better understanding of the estate plan that you had written for you, and you want to know what's actually going to happen. And I want to tell you that I can help you with that. I can help you if any of these are an issue that you're facing, or if it's something else. If you have another question or another concern that you want addressed tonight, I hope that you will put that concern in the chat or in the Q&A, and I can see both of those, and I'll be sure to answer your questions tonight. But really, whatever the case, I want you to know that you're in the right place here with me tonight if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online or fill in the blank kind of will, but you're not sure if it's going to work, if it's going to take care of your family. I can answer that question for you tonight. And you're in the right place if you're nervous about how much this is going to cost. And I really get that as somebody who is cost conscious themselves. I totally get that concern around cost and expense. And we'll talk about that tonight. I can tell you exactly what you can expect to pay for an estate plan. And I'll also give you some offers at the end that will make it even more affordable to get a great estate plan in place for your family. You know, the reality is estate planning isn't about us. And that's something that really rang true for me, for my wife and I recently when we updated our plan, is that we were never going to be enriched by our estate plan. We were never going to make money off of our estate plan, not off of our estate plan. It was really about our kids. And those are the three people that you see pictured there. And from left to right, it's Margaret, Ben, and Elizabeth. Margaret is 4, Ben is 9, and Elizabeth is 6. And when we were updating our estate plan, that's who we were thinking about. That's who was on our mind. And the fact that they were going to know, our loved ones were going to know whether we lived up to our promise to take care of it. Or my parents were going to know, my sister, my wife's family was going to know as well, whether or not we took care of it. And they were going to be impacted. The most impacted were going to be our kids. So I see somebody has posted a question here. My mother is 87. She owns property and has investments. Her mental state is declining. She refuses to work on her estate plan. That is really tough. Something that I've heard from a lot of people. And I see here, when I try to talk with her about estate planning, she thinks I want to steal her money. Yeah. It's really hard. It is really hard to have these conversations with parents who are older and who don't have experience working in this field. One thing that I have seen success with, or that I've seen that can help, is sharing information. Like this webinar. Again, I'm going to send you a recording of this webinar. If you think it would be useful, you can certainly send this on to your mother. But I completely get that, and my heart really goes out to you. We're going to talk about some things tonight that are going to make it clear that things are going to be complicated for you and for your mom's family after she's gone. And things are going to be complicated enough because you're going to be grieving her. And if she's, declining in mental state at the same time, that window may be even shorter where things are going to be complicated. And it is so important to plan. And I think that that you're here tonight. But I really encourage you to send information along, because that's not a way where you're demanding something or anything like that. It's just sharing information with her about this, and maybe that would be useful for you. So here is what we're going to talk about today. Here are some of the things that we're going to talk about. We're going to talk about planning for incapacity. We're going to talk about who can make healthcare decisions for you, who can make financial decisions for you if something happens to you and you become incapacitated. And that could mean something like a declining mental state. It could mean something like dementia. It could also mean something like a car accident and ending up in a coma. Who can make those kinds of decisions for you? And how can you get somebody in place so that the right person, the person you want, is making those decisions for you? We're also going to talk about planning for when you pass away. And that's what most people think about when they think about estate planning, is planning for when you're gone, planning for when you're dead. And so if you have minor children, that probably means guardianship. In fact, I know it means guardianship if you have minor children, but it can also, there's a lot of other things to plan for in passing away. Planning for your assets, planning for probate, the court process that happens after you're gone for your estate. We're going to talk about the time, cost, and public nature of probate tonight. We're going to talk about estate taxes and what those are on the federal level as well as on the Minnesota level. We're going to talk about unclaimed property as well, and what that is and how assets become unclaimed or end up in the Minnesota Department of Unclaimed Property. We're also going to talk about intangible assets, things like your stories and your values, and how you can make sure that those are shared with the people coming after you, the people that you want to have access to those intangible assets. But first, before we start talking about those things, I just want you to know a little bit more about me and who I am and where I am, really. So this is my family. My wife's name is Tobin. And again, my kids here are Elizabeth on the left, Margaret in the middle, and Ben on the right. And we live in Bloomington, Minnesota. And really, my family is my whole world. I spend a lot of time with them. I really love them, and I'm really happy to have them. So I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, my son, Ben, was born. After law school, I found a job with a small estate planning law firm, and I loved the clients that I was able to work with. But at the same time, I didn't always feel like I was providing the value that my clients deserved. And so after a little over 3 years, I actually left that law firm. And this is a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this was not said about me. I just have to say that from the start. But this is something that has really stayed with me from my parents' extremely negative experience with the estate planning attorney who helped my grandmother to plan her estate. And in particular, I remember my mom saying someone has to graduate at the bottom of the class. And there was a big reason for her frustration, for my parents' frustration with this attorney. I don't actually think it was the attorney's knowledge. I don't think this attorney actually was the dullest knife in that class drawer or whatever. But I think that this attorney was practicing under kind of a faulty model. And I'm going to talk about that faulty model in a little bit. I call it planning for death, and really how you can avoid having an attorney who's practicing under that faulty model, and how you can make sure that you are getting the estate plan in place that is really going to serve the people that you love in the best way. So let me see here. I have another poll here that I want to put up just to see kind of the demographics of people in attendance here, and to see where people are at. So if you don't mind answering the demographics question, or the what best describes you question, I'd appreciate seeing your answers on this. My guess is that not everybody has minor kids here tonight. In fact, I'm seeing some people answer that they don't have kids. But I want to touch on guardianship, which is such a crucial issue for anybody who's joining us here tonight and who has minor kids. And in particular, there are two types of guardianship that are really important. And the first one is short-term guardianship. What happens when mom and dad don't come home? What happens when the kids are left with a babysitter? For whatever reason, mom and dad don't come home and there's no plan in place. And what happens eventually is that babysitter realizes that something is wrong, calls the police show up, and Child Protective Services gets involved. And that's kind of the natural thing to have happen. The police don't want the liability of giving the kids to somebody who doesn't belong with them. Child Protective Services is just the natural place where those kids end up going. And I don't want to say anything negative really about Child Protective Services, other than I don't want my kids to ever end up in Child Protective Services. I know that's not where they would do well, where they would flourish, especially in a situation where they don't know where mom and dad are and something has happened to mom and dad. I want my kids to be with family. And so that's why my wife and I have made short-term guardianship nominations and made those available. So if something ever happened to us where we weren't able to come home, somebody in our family would be able to take our kids and take care of them until they figured out what had happened to us, or until our long-term guardians were able to take the kids and take care of them. And I see same for adult protective services. Yeah, people don't want that either. Nobody wants to go into adult protective services either. That's right. Long-term guardianship. So long-term guardianship is who is going to raise the kids until they're 18 and able to be out on their own. And if there isn't a plan in place that's been written by the parents, the truth is that there is a plan, and that plan is that a judge is going to decide for you. And unfortunately, that probably means it's a plan that you're not going to like, because what they think makes the ideal guardian for your child may not be what you think makes the ideal guardian for your child. And I don't want to dwell on this too much, because again, I know that some people here don't have minor kids, so I'm going to skip and keep moving past this. But I just want you to know that that is so important. And if you know anybody who has minor kids, if you're here and you have minor kids, I hope that you'll reach out to me and we can at least get some guardianship in place for those kids in case something happens to you. All right, so let's talk about assets and how your family is going to receive your assets. And in particular, I want to talk about this court process called probate. And the truth is, if you have no estate plan in place, or if your estate plan is based on a will, then the state has a plan for you. And that state's plan, Minnesota's plan for you, is called probate. And probate is the process during which your assets are transferred to your heirs after your death. And so you need somebody who can stand in your shoes as the owner of this property or as the owner of your estate and make decisions about it, including selling it, investing it, transferring it based on the provisions either in the will or in the statutes of the state where you live. And that process of getting somebody in place, getting somebody to stand in your shoes is called probate. Sometimes the court will oversee the actions that they're taking. Sometimes the court is only involved to the extent that they're getting somebody in place to make those decisions. But either way, I got to tell you, probate is slow. In Minnesota, probate takes a minimum of 6 to 12 months. More often, it takes something like 12 to 18 months. And we'd like it to go faster, but it just can't. It's designed to go slow, in part because they want to make sure that all of the creditors get paid. And so there are, you can see down at the bottom, probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors, to make sure that those creditors get notified that you've passed away and that those creditors are able to line up and be paid for the debts that you owed them during your life. It's not a very pleasant process, but it is the default. Probate's also very costly. There are attorney's fees and executor's fees, appraiser's fees, all kinds of different costs and fees that go into probate. And so an average estimate of what probate might cost here in Minnesota is something like 3 to 6% of the gross value of the estate. So you can imagine if all that you own is a house worth $400,000, which is a pretty nice house, I'll grant you, although with real estate prices the way that they are, $400,000 certainly isn't unreasonable. But with a $400,000 house, probate's already going to cost somewhere between $12,000 and $24,000 for that asset. And so we'll have a chance here in a little bit to calculate the probate estate for your assets as well. Probate's also public, and I'm showing you here Anna Nicole Smith's will. And it's been a really long time since we've heard anything about her. But this is Anna Nicole Smith's will. And the reason that I have access to this is because wills are totally public, and having a will doesn't avoid probate. In fact, it requires that there be a probate where the will is submitted to the court and becomes a public record that anybody can access. And we have this really goofy saying in the estate planning world, where there's a will, there's a probate. Again, if you're relying on a will as the foundational document of your estate plan, then you are guaranteeing that there's going to be a probate down the road. And something that is kind of unnerving, when a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money, because it has those distribution provisions in there. It has the names of the people who are receiving distributions. And there are documents that we have to file in probate that detail the inventory of your estate, as well as an accounting of exactly where those assets are and what they're being used for, including distributions, which is really unnerving. Minor children also receive assets at 18 and unprotected. I think that we all have stories, or we've all heard stories before, about people receiving assets at too young of an age, and how it can really spoil them financially and really cause them to make some bad decisions about education, bad decisions about their life that really negatively impact them for a long time. Okay, so I promised we would have a chance to calculate the probate, your probate estate. And so here is that opportunity. And so I have here kind of a sample estate that we can calculate the probate costs, or the possible probate costs on. And so I have a family home that's worth $300,000, a rental property worth $250,000, some furniture and household goods, we call it personal property, that's $30,000. Some automobiles, a couple automobiles that are worth $50,000, stocks, bonds, bank accounts totaling $120,000, and a business interest, which is $100,000. None of those transfer by beneficiary designation. All of those would need to transfer through the probate process, generally by default. That's how these things generally go, is they go through a probate because they are in your estate when you pass away. They don't transfer by beneficiary designation generally. So you can calculate 5% of the gross value of your estate by just moving the comma over one place. So I have 850,000, now I have 85,000, and then dividing that number in half. And that gave me the $42,500 over here that you can see. That's how you can calculate really quickly. You can get to 5%, and 5% falls in the middle of that 3 to 6% range. So you have kind of a back of the envelope math of what your probate estate might cost. And again, it's not just attorney's fees that are going into this. There are court fees that are just non-negotiable that have to be paid. There are appraisal fees, there are accounting fees and business valuation fees and bond fees and all these other miscellaneous fees, including executors or personal representative fees, all kinds of different fees that just need to be paid in order to get an estate through probate. But the good news is that this is voluntary. It is totally avoidable, and I'll tell you in just a second how it can be avoided. Just to add a little wrinkle, life insurance and retirement accounts generally go by beneficiary designation. And that's great news that they would pass by beneficiary designation. And so you generally shouldn't have to worry about those assets going through probate. But if you have those life insurance proceeds or retirement accounts payable to a minor, then those assets cannot avoid probate. They cannot go directly to a minor. Somebody has to be found who can take those assets for that minor child. And so when you have to find somebody to take those assets, you're looking at a conservatorship of some kind or some other process to find somebody who can hold on to the assets for the child. Again, this is assuming that you don't have that you have something like a will in place without testamentary trust, or that you have something in place that's not taking care of those assets and that they're just going directly to a minor. They would add in to that gross estate, and therefore they'd add to the possible costs and fees that that would be incurred by going through the probate process. Again, this is totally voluntary. This is completely avoidable, and there is a foolproof way of avoiding probate by fully funding a living trust. And what a living trust is, it's an agreement that you sign with yourself. It is like a contract that you sign with yourself about how the assets are going to be handled, and you're able to name a trustee. And so instead of having the probate court name somebody to act in your shoes, in your stead, you are actually able to put that trustee in a position where they can stand up and act in your shoes as soon as something happens to you, meaning incapacity or death. And that's really fantastic. Having that person, that trustee, able to step in and stand in your shoes means that they're able to, one analogy that I've heard is, imagine stacking up all of your assets in a wagon. Well, with a successor trustee, if you drop the handle of that wagon, a successor trustee can just come along and pick up the handle and carry on moving forward. It's not true with a will. Unfortunately, with a will, you have to go through the probate process. You're only nominating somebody to be your personal representative. You're not actually putting them in place as personal representative or making them your personal representative. The court has to approve their nomination, and the court often has to oversee the actions that they're taking, especially if their credit isn't completely stellar. And so, so that's the difference between a trust and a will. But with a trust, you're able to name the successor trustee. But it's really important that you make sure that everything goes into the wagon as well, that it is fully funded. And what fully funded means is doing things like retitling any investment accounts that you have in the name of the trust, going down to the bank and signing new signature cards at the bank so that they go into the trust. Those bank accounts go into the trust, executing deeds to real property and quitclaiming those properties into the trust, transferring stock and bond certificates so that they are in the name of the trust, assigning personal property with a document like an assignment of personal property or a bill of sale into the trust, and then changing life insurance and retirement account beneficiary designations. So when something happens to you and you're gone, those life insurance proceeds and retirement accounts flow by operation of law directly into the trust, as opposed to having to go through probate. And again, this is foolproof. It is a way that you can absolutely guarantee that you're going to avoid probate, is by having an attorney write this trust agreement, write this contract for you, and then fully funding that living trust so that everything is in the trust. All right. Well, here we have an opportunity to calculate our estate tax. And the good news for almost everybody is that the estate tax only applies to a very select population. Right now, here in 2021, the federal exemption is $11.7 million. And that means for your first $11.7 million that you have, you pay nothing in estate taxes. Once you get above that amount, you start to pay at a pretty steep rate, and you go all the way up to 40% of anything that's passing to the next generation. You pay over to the federal government 40% of it. So it can be really steep, but again, it doesn't apply to almost anybody. And again, this is not the reason that most people are doing estate planning. There's also in Minnesota an estate tax. And in Minnesota, we have an exemption as well. The exemption is lower, but it is still a pretty high exemption for most people. And that exemption is $3 million. Once you get above $3 million, you start paying at 13%, and that rate goes all the way up to 16%, depending on how high above $3 million you are. But again, it doesn't apply to most people. And in fact, if you are married, you actually get to double the federal number automatically, that there's something called portability. And so when the second spouse passes away, they ask the estate, did the first spouse use any of their exemption? No? Well, great. Then bring their exemption over and double that number. So it's really $23.4 million if you're married that gets to go through estate tax free. In Minnesota, you can also double that estate tax exemption by doing some planning and taking advantage of doing some planning to make sure that you double that number. It's complicated, but basically what happens is when the first person passes away, you treat those assets. They shouldn't have to go through an estate tax treatment, but if you're over $3 million, you often take some of those assets and treat them like they have to go through the estate tax process by something called a disclaimer. I'm getting into the weeds here, but basically what you do is you do some accounting and some tax treatment at the first death, and then you preserve that already taxed treatment. So when the second person passes away, those assets no longer have to be subject to that tax after the second person passes away. So what do you really need to know? You need to know that if you have assets in excess of $3 million, even if you're married, you need to work with an estate planning attorney in order to make sure that you are able to secure the best tax treatment for your assets. That's what you really need to know. And that's really what I have to tell you. So this is something that a lot of estate planning attorneys don't cover, that they don't talk about, that's not on their radar. And that's, will your assets be lost to the state? And so right now in Minnesota, in our State Department of Unclaimed Property, there is currently $700 million sitting in the Minnesota Department of Unclaimed Property. And a big part of the way that those assets get there is that somebody passes away and their heirs, their family, isn't aware of all of the assets that person had and that person should have passed on to the next generation. And so things get lost. And I can tell you, as somebody who's handled probates, one of the big things that we do is go through the mail and we go through the statements that person receives after they're gone. And with electronic statements turned on, you can imagine that a lot of times it's easy to miss things like bank accounts or stock that's held in an exchange or something like that, investment accounts that don't have statements coming to the house anymore. If somebody in your family isn't aware of it, that item risks being lost to the State Department of Unclaimed Property after you're gone. And so again, this isn't something that a lot of estate planning attorneys cover, but I think this is so important. And as somebody who is still building their assets and building the inheritance that I want my kids to receive someday, I can tell you it is important to me that my kids get everything that I have to give them. And I don't want anything to be lost. I don't want anything to be sitting stationary in the State Department of Unclaimed Property because it was missed when I passed away. And so this is something that's really important. And it's something that working with an estate planning attorney like myself, we can make sure that we get covered and we make sure that everything makes it to that transition to the people that you want to receive it. This is really cool. So there is a way in your estate plan, in your trust, that you can turn it into a real treasure chest. And what I mean by that is you can give the inheritance that you're giving to your heirs, you can give that inheritance asset protection. You can build in protection for it so that it's protected from things like divorce and things like lawsuits from creditors. It is so cool. The way that we can do this, we can build in a lifetime asset protection trust for your kids or for the next generation to receive. And it's something that they really can't give themselves, this asset protection. You can't do it as a first person. You can only have someone do it for you. And so you can build this into their inheritance and make sure that those assets are protected so that a spouse, a divorcing spouse down the road isn't able to take half of the inheritance that you wanted them to receive, but that everything remains theirs and that they're able to use it and spend it on things that they want to spend it on, as opposed to having it go to a divorcing spouse in a divorce situation. All right, so this is something that I know is very real right now for a lot of people, planning for incapacity. And in particular for incapacity, we're talking about somebody who can make financial decisions for you, somebody who can make healthcare decisions for you. The person that I have pictured here is Terri Schiavo. And I imagine that some people remember Terri and some people remember what happened and what she went through and what her family went through after she ended up in a vegetative state. And she ended up in a vegetative state. There was an issue with her heart, and she ended up in this state where it wasn't clear that Terri was interacting with the world anymore. And her husband had one theory of what Terri would want. And Terri's husband believed that Terri would not want to live in this vegetative state anymore, where her interaction with the world was so limited and so difficult. Her parents, on the other hand, believed that Terri would still want to remain in the world, would still want to receive life-sustaining treatment, so long as there was any possibility that Terri was interacting with the world. So as long as there was any chance that she might come out of it, or that she might have a better interaction with the world. And so they were at odds with each other. And the husband was really the one who had been given the right to make decisions for Terri. But there were a lot of court cases that came out of it about what Terri really would want and who could make that decision. And it was a really difficult thing for the family. It was a really difficult thing for the entire country to watch these cases and to watch what was going on and all of the fighting. And this isn't to cast aspersions onto Terri, because it's there's no call for doing that. But you could put healthcare decisions, you can actually put what you want for your healthcare down into a document called a healthcare directive or a living will, so that your family knows exactly what it is that you would want if you were in a situation like Terri's. And so you can give them that piece to make the decision that you would want made if that was you, if you were in that same position that Terri ended up in. All right, so we've talked about a lot of things tonight. We've talked about probate, and we've talked about guardianship for minor kids. We've talked about making sure that all of your assets get to the next generation. Nothing is lost to the State Department of Unclaimed Property. We've talked about estate taxes, and I know, that doesn't apply to a lot of people, but the people that it does apply to, they really want to make sure that they have something in place. We've talked about planning for incapacity, including financial decisions, a financial decision maker and a healthcare decision maker, we've talked about a lot of things. And so you're probably having this thought right now. What can I do to do the right thing for my family? And what should it cost to plan right? And really, if something that I've talked about tonight has resonated with you and you want to get an estate plan in place, you want to get some kind of plan in place, you really have two options. You can either do it yourself or you can work with a lawyer. And do keep in mind, not all lawyers are the same. And we'll talk about how you can get the right lawyer if that's the right option for you. But first, let's talk about if it makes sense to do it yourself. And here I have some different criteria in place where it would probably be beneficial to work with a lawyer. And sometimes you just have to work with a lawyer. There's just no way around it. If you want to do something in particular, you just need to work with an attorney. But if you own more than just personal belongings, if you own more than just your car, clothing, jewelry, furnishings, that kind of thing, if you own more than that, if you own real estate, if you own assets in excess of $75,000, if you have substantial retirement savings, if you have a life insurance policy, then you would really benefit from working with an attorney. If all that you have is your car, if you're renting an apartment and all you have is clothing and jewelry and some furnishings in your apartment, then you might be okay to try and do it yourself. There are some do-it-yourself plans that might serve you well. But if you have more than that, especially if you have a home, if you have significant assets, then you probably benefit from working with an attorney. If you want to ensure that the people that you love stay out of court and out of conflict, and you want to ensure that those people have somebody to turn to when something happens to you, then you really need to work with an attorney. You need to work with somebody who knows this area and can ensure that your family will be able to stay out of court and conflict, and to be that person that they can turn to. That's got to be an attorney to do that, to step into that role. If you want a kids protection plan, which includes short-term guardianship, long-term guardianship, as well as other documents for your minor children, like a medical power of attorney, or if you want to avoid probate or estate taxes, or if you want to protect the inheritance that's going to your heirs, to the people that you love, with something like asset protection to protect it from divorce, then you have to work with an attorney. That's the only way to get those things done, is to work with an attorney. And if you want to guarantee that your plan is going to work when your family needs it to work, then you have to work with an attorney. You have to work with somebody who's experienced in this area, and not try and do it yourself. And especially with that last bullet point, I tell this story that about a year ago, it was maybe it was even a year and a half ago. It was a while ago now at this point, but my son and I were going to go fishing together. And I was putting fishing line on his rod and reel. And it was a new rod and reel that we just had shipped to us. And I was putting fishing line on it, and I don't know what I did. I don't think I wound it the wrong way. I think I probably put too much fishing line on the reel, or I had it going onto the reel the wrong direction or something like that. But as soon as I got done, as soon as I thought that we were ready to go and I snipped the fishing line off of the spool, all of a sudden that fishing line started jumping off of the reel, and it was everywhere, and it was a total mess, and it was all tangled, and it was a big mess that I had created. And it was frustrating, but it was a do-it-yourself project that had gone wrong. But guess what? I was able to just snip the line further up. I was able to pull the line out, and I got everything working. We were able to go fishing. It cost me some time. It cost me, I don't know, 20 cents in used fishing line, something like that. But it wasn't a big deal. I had immediate feedback that my do-it-yourself project hadn't worked. It didn't cost me very much. I didn't risk very much. Just cost me some time and about 20 cents in fishing line. An estate plan is not like that. If you do it yourself with an estate plan, number one, you're not going to know whether it's going to work or not until you're gone and you can't clean it up anymore. It's not going to be clear whether that estate plan is going to work until you have passed on and your family is trying to deal with that estate plan and trying to make it work and trying to do what it is that you were attempting to ask be done. Number two, it's expensive. If your estate plan doesn't work, it means that your family is going to be going through probate. It's going to cost your estate a lot. It's going to be an expensive process. It's also going to be time consuming, and it's going to take a lot of energy from the family when they're grieving and when they really need to be putting that energy into being there for each other and making sure to build each other up. So doing it yourself with an estate plan, if you have more than just cars, belongings, clothing, jewelry, furnishings, I really encourage you to work with an attorney to make sure that you get it right. Here's another thing. If you want to give your assets to someone other than your kids, maybe you don't have kids, or maybe your kids just aren't your preferred beneficiary of your assets, then you really need to work with an attorney to make sure that you get those distribution provisions exactly right to make sure that the right people are receiving. Someone has to graduate at the bottom of the class. And I want to come back to this phrase. Again, this was not about me. This was said about another attorney who helped my grandmother to plan her estate. And she was really underserved by the job that this attorney did. But again, I don't think that it was this attorney's knowledge or I don't think it was the fact that they were a dense person. I think that it was the fact that they were practicing under a model, again, I call planning for death. And it's the typical experience that you have when working with an estate planning attorney. And that typical experience looks like this. You're going to get form documents that are kind of set it and forget it. They're going to plug your name in a couple of different places, maybe plug your address in, and that's about all that they're going to do on those form documents. And they're going to give them to you. They won't educate you about them. They won't empower you to make decisions over the provisions in those documents. They're just going to plug your name in a couple of places and then tell you that you're good to go. You're not going to understand those documents, and you're going to walk away thinking, well, I have a document, so I'm probably covered. You're going to put the document in a desk drawer and you're not going to look at it again, but your family is going to find it when something happens to you. And it's going to be questionable about whether that form document is really going to take care of your family in the way that you intended to take care of your family, especially if you didn't understand what that form document said. Typical experience isn't going to keep money out of the Minnesota Department of Unclaimed Property. Again, that's just not something that most estate planning attorneys have on their radar. It's just not something that they are focused on doing. Typical experience may avoid probate, but it may not. And a lot of estate planning attorneys don't even attempt to avoid probate. They will just write a will for you with the knowledge that if your estate needs to be probated later, they're going to have the work of that probate as well, because a lot of estate planning attorneys do probate, and they'll just collect the money for writing you that will that's not going to keep your family out of probate, and then collect the money for the cost of probate for the attorney that your family needs to hire to do the probate, because they're the most natural attorney to go to since they drafted the documents. Sad, but I've seen it before. Typical experience probably isn't going to keep your family out of conflict. The typical experience is only going to focus on money. It's not going to focus on things like your values and your stories that can be passed in something that I do. It's called a family wealth legacy interview, where we're able to capture some of those stories and capture some of those values that you have and make sure that your family knows about those and that you're able to share them in a recorded interview that we do together. Typical experience is going to leave assets to heirs completely unprotected. If a divorcing spouse wants to take half of the inheritance, a lot of times that money just ends up in a joint account where the divorcing spouse has access to it and can do something like take half of the inheritance, which is, I know, not what most of the people that I work with want to have happen to that inheritance, that they want to go to their heirs directly. Typical experience is not going to give you ongoing legal guidance, and that's because the typical experience, most estate planning attorneys charge hourly, and they're going to bill you hourly for any future phone calls or future emails that are going into them or coming out from them, and that's really frustrating to a lot of people, especially when they pay an attorney to help them to draft a plan, and then they can't ask questions after the fact because they just end up getting these bills in the mail for hourly fees. Really frustrating, and not serving clients in the way that I think clients should be served. Typical experience is also not going to adequately protect kids. Oftentimes, a long-term guardianship nomination is made in a will, but that long-term nomination is only actually works when that will is admitted to probate. And so there are ways that you can make those guardianship nominations outside of a will that I think really serve the family much better than having them only in the will. As well as that immediate or short-term guardianship that is so important for minor kids. And really, with the typical experience, you're just going to be left with this question: is this going to work when I need it to work? And that's never a question that you should have after working with an attorney who should be educating you and should be empowering you to make the decisions about your estate plan that you want to have made. Planning with me is totally different, and I call it planning for life. It's a completely different experience because I charge only flat fees where you choose the fee based on your finances and based on what you want for your family. And I will give you some guidance. I'll talk about what we can do under the different packages and under the different flat fee structures. And then you choose what you want for your family. And again, I want to empower you. I want you to be the one making the decision, and you are the one. Your family is the one that is going to live with the consequences of it. And I want it to be your decision. I want to really empower you to do that. Planning with me means that you're going to keep your money out of the hands of the state. And I do that by creating an inventory of my clients' assets, and then keeping a copy of that inventory, and I keep it secure so that it is available for your family if something happens to you, but it's kept secure before then or outside of that. Planning with me protects kids totally. Minor kids are protected in the short term and the long term through guardianship nominations for short-term guardians as well as long-term guardians. Planning with me keeps families out of court and out of conflict. That is so important to me. Really, at heart, I'm a peacemaker, and I believe that my role as an estate planning attorney is being a peacemaker and keeping the peace in the family when they lose a vital linchpin like you. And so that is really at the heart of my law firm, and something that I'm really passionate about is keeping families out of court and conflict. Planning with me means that you're going to know that you've made the right decisions because I'm going to educate you along the way, and I'm going to empower you to make those decisions once you have the information that you need to make them. But again, those decisions have to come from you in order to be meaningful and in order to give voice to what you have going for your family. Planning with me means you can protect the family money from outsiders, from things like divorce, from things like lawsuits from creditors. Again, using that asset protection, that lifetime asset protection that you can build in for the people that you love. And planning with me means having a lifetime of guidance and protection, because I'm not going to charge you those hourly fees for picking up the phone and calling me and telling me that you have a new grandbaby or telling me that you bought the house of your dreams. I want you to call me. I want you to know that you can call me and share that happy news with me, or email me if that's what you prefer. But I want to keep contact because that relationship between us is so important to continue. And that relationship is really what's going to ensure that your estate plan remains working even after we've done the work of writing the plan together. And planning with me, it means that your plan is going to work when your family needs it to work. And again, it's really a gift that you're giving to the people that you love the most. So what should this cost? And I know that this is something that is often on people's mind when they talk about working with an attorney and when they talk about working with an estate planning attorney. And so I want to give some information about this question in particular. First off, if all that you have is a house worth $400,000. And again, I recognize that's a pretty nice house, but if all that you have is a house worth $400,000, avoiding probate, making sure that you're able to avoid probate, is going to save your family at least $12,000. That's 3% of that $400,000 house. If you have assets over $3 million here in Minnesota, then this planning is going to save your family at least 13 cents for every dollar in excess of $3 million. And again, that's the estate tax here in Minnesota. And the estate tax exemption is $3 million, with the rate kicking in at 13% after that $3 million, all the way up to 16% as you get above that $3 million figure. A typical estate planning attorney is going to charge at least $1,500 for an estate plan. And again, you can be almost guaranteed that it's not going to keep your family out of court and conflict. It's not going to ensure that your assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your money. It's not going to cover minor kids' immediate care, nor the values, insights, stories, and experiences that are so valuable and that so often are lost. Or you can plan with me. And planning with me, I'm a personal family lawyer. And what that means is that I work directly with you. I work directly with your family to make sure that we get an estate plan in place that is going to work when you need it to work. And that fee ranges somewhere between $2,000 and $8,000, again, depending on what you want for your family and what fits within your budget. And I've done plans for less than $2,000. I've never done an $8,000 plan. Most of the plans that I do really fall somewhere between $4,000 and $5,000. That's where most people end up. And working with me, you're going to know that your plan is going to work when your family needs it to work. And so I really want to make this easy for everybody. I'm going to share a link here where you can see my calendar, where you can see my schedule, and you can actually sign up for a family wealth planning session. And so what is a family wealth planning session? A family wealth planning session, first off, I want to give it to you completely free. It has a value of $750 because it's 2 hours with me where we're going to talk about everything specific to your situation. We're going to talk about your assets. We're going to talk about your family, and we're going to talk about what would happen in the case that you left this earth, or what would happen in the case that you became incapacitated. And we can get really clear on that. I can do a lot of educating around the specifics of your situation so that it's really clear what's going to happen. And I want to give you that family wealth planning session for absolutely free, just for attending here tonight. I do want you to do some homework ahead of our session so that it can be as useful as possible. But I really want to give you this no charge 2-hour-long meeting, this 2-hour-long family wealth planning session where we can talk about everything and you can get really clear. You can get really educated on exactly what's going to happen in your situation. And it really breaks down into 2 halves. The first half, the first hour, is really educational, and it's really talking about the things that we've talked about tonight in specifics to your assets and to your family. And the second half, if you want to continue into actually designing your plan and creating a plan that is going to take care of your family, the second half of the meeting is the design of that plan and is building out whatever you want to have for your family and making sure that what you want to have happen is going to happen. And again, I want to empower you to make the decisions about exactly what's going to happen to your family. And that's what we're doing in that second part. Is I'm empowering you by presenting questions to you, by presenting decision points to you, making sure that you completely understand the ramifications of that decision, and then giving you the power to make those decisions so that you are taking control and you're making sure that what happens in your family is what you want to have happen in your family. And I want to give you $250 off the plan that you build in that family wealth planning session with me. I want to give you $250 towards the plan of your choice. Again, it's those flat fee plans ranging somewhere between $2,000 and $8,000. I want to give you $250 towards that plan if you reserve your appointment before the end of the week. And when I say end of the week, I mean the end of the day, Saturday, which is I define as 5 p.m. on Saturday. And so the first step to do that is to click through to my link and sign yourself up for a family wealth planning session. And again, the meeting doesn't have to be before the end of the week. It's just that you need to reserve that meeting before the end of the week. And I really hope that you'll do that. I love this. I love meeting with people, and I love talking through everything with them, in this family wealth planning session. I am an educator. I believe really strongly in this education and empowerment. And so I love doing this. I love being able to meet with people and to help them through this process so that they completely understand exactly what's going to happen for their family, and that they're able to make decisions and take steps to get things in place to take care of their family. And so even if we go through that family wealth planning session, we talk for that first hour, and everything about your situation is already the way that you want it to be, well, then you have the information that everything is exactly as you want it to be. And you have the information that you don't need to design a plan, because everything is already going to be taken care of in the way that you want it to be taken care of. And you can leave that meeting very happy. You can leave that no obligation meeting having paid nothing, but gained the knowledge and gained the comfort that you have exactly what you want to have happen. What you want to have happen is already going to happen. If the situation is that you would benefit from having a plan in place, from taking control and writing your own plan as opposed to following what the state's plan says for you, then you can use, again, that $250 towards that plan of your choice. Again, the first step here is just to go to that link, take a look at what I have available for times, click on Family Wealth Planning Session. I probably don't have any time left here in December. In fact, I see that there's no time left in December. But go ahead and click through, and you can see that I do have time available in January. I even have a Saturday available in January. And I hope that you'll click through to that and book your time to meet with me, because I really do want to meet with you. So I'm looking here, I'm seeing if there are any questions that are coming through, and I don't see anything immediately coming through in either the chat or the Q&A, but I will stay on here for just a second just to see if anything else is coming through, and to give everybody a little bit of time so that if they want to click through, they can click through here. Let me just see if anybody is following and is looking to get involved on the Facebook, on the Facebook. And I sound old when I talk like that, but I remember when it was called the Facebook. So that's my defense to that. Yeah, and I'm not seeing anything. Anyway, I want to thank everybody for attending tonight. This has been a great group. Thank you for being involved in the polls and for asking questions and sharing insights. I really appreciate it. I really enjoyed having you here tonight. Again, I hope that we are going to have a chance to meet. I hope that we're going to have a chance to work together and to make sure that your family is taken care of in the way that you want them to be taken care of. I am going to go ahead and end our meeting here tonight. But again, I just want to thank you and congratulate you for sticking with me, educating yourself, and getting this information. And again, I hope that we can meet soon. Have a good night.